Hello, good morning, and welcome to Byjus Exam Prep. Yesterday, we discussed Article 17, which talks about untouchability is abolished and its practice in all its forms is forbidden. Then we looked at Article 18, which talks about abolition of titles. No titles can be awarded, can be conferred by the state under Article 12, except academic titles and military titles. And then there are other clauses which we have discussed. For example, no Indian citizen can accept the title from a foreign state. Then we looked at Article 19, and there we discussed various natural rights. And I told you natural rights are those which occur to an individual because of the accident of birth. For example, freedom of speech and expression. And we discussed what is freedom of speech and expression. Does it include hate speech as well? No, it does not. What are the reasonable restrictions on freedom of speech and expression? Is sedition one ground on the basis of which your freedom of speech and expression can be restricted? If freedom was not a reasonable restriction, how, because of judiciary, it became constitutional? Because previously it was thought that sedition law would have no place in India, in a constitutional India, because the citizens should have the right to promote disaffection against the government. But the Supreme Court said in Kedarnath case that yes, citizens have the right to ask questions of the government, but you cannot incite people to violence. That's the only thing that the people cannot do. Otherwise, you have freedom of speech and expression. Then we looked at other natural rights, for example, the right to form unions, associations, and cooperative societies, a right to assemble peacefully at a public place without arms, the freedom to move, the right to movement throughout the territory of India, the freedom to reside and settle anywhere within the territory of India. And obviously, these are not absolute rights. There are restrictions that can be imposed on these rights, including your right to take up any trade, occupation, profession. Clear? Now let's look at Article 20 of the Constitution, protection in respect of conviction for offenses. And there are three clauses we have to discuss today under Article 20, Clause 1, Clause 2, Clause 3. But you don't have to remember and memorize Clause 1, 2, 3. Just understand the concept. What is the broad concept behind Article 20? Article 20, Clause 1 says, no person shall be convicted of any offense except for violation of the law in force at the time of the commission of the act. What does that mean? Let me give you an example. December 2012. Nirbhaya, the example that I've cited previously. Nirbhaya, although that's not the real name of this lady who was gang raped and then ultimately, unfortunately, lost her life. Because according to the laws in India, you cannot reveal the identity of the rape victim. In fact, you cannot reveal the identity of those closer to the rape victim, because if you reveal their identity, you're basically revealing the identity of the rape victim as well. So the identity of the rape victim cannot be revealed. Although we know what is the name of this lady, but we can't say that. Why? Because that is prohibited by the law. Nirbhaya, fearless. This name was given by the media, by the protesters for this lady. She was gang raped in a moving bus, and there were close to 6 individuals involved. One such individual was a juvenile. Juvenile, according to the law, the definition was any person less than the age of 18. And in 2012, there was a law known as Juvenile Justice Act 1986, which was in force. According to this law, If a juvenile is in conflict with law, in conflict with law means a person has basically committed a crime, violated this law. So this juvenile, if this juvenile is in conflict with the law, maximum punishment that can be awarded to this juvenile is 3 years, not in a regular jail, but in a reform home. Article 14 of the Constitution, equal protection of the laws. Like should be treated alike. Those who are in similar circumstances should be treated similarly. But the idea is that if there is an individual juvenile less than the age of 18, you cannot equate this juvenile with an adult. The adult has the full mind and capacity. The adult has the complete understanding of what he or she is doing, what are the repercussions, what are the impacts of the crimes that he will commit, of the actions that he will take. So you can't equate juveniles with the adults. That is why there should be separate courts for juveniles, separate reform homes for juveniles, and the maximum punishment that can be awarded to this juvenile is a 3-year imprisonment, that too not in a regular home, regular jail, but in a reform home. This juvenile, some people said was 3 months short of 18 years. Some people said was 6 months short of 18 years. But be that as it may, there were also demands that this juvenile should be hanged. Why? Because if you are old enough to rape, you are old enough to die as well, to hang as well. So if this individual knows what he is doing by raping this poor lady, he should also bear the consequences of his act. But what was the law at that time? When you committed this crime, what was the law? The law said you can be sentenced, maximum punishment that can be awarded to you is a 3-year sentence in a reform home. In response to this Nirbhaya's gang rape and ultimately unfortunate death, this Juvenile Justice Act was amended in 2015. When it was amended in 2015, it said a boy in the age group of 16 to 18 years, if this individual has committed a heinous crime, this individual can be tried as an adult. But for that, we need to take the help from Juvenile Justice Board. When you can be tried as an adult, that means life imprisonment can also be given. In 2015, this law, the real name of this law is Protection of Children, Care and Protection Act, or Juvenile Justice Care and Protection Act of 2015. According to this law, if a boy in the age group of 16 to 18 has committed a heinous crime, and what is a heinous crime? For which the minimum punishment is 7 years. Any crime under Indian Penal Code for which the minimum punishment is 7 years, maximum can be death as well, life imprisonment as well. If the minimum punishment is 7 years, this is a heinous crime. And if a boy in the age group of 16 to 18 has committed this heinous crime, then this boy can be tried as an adult. Can be tried as an adult. Not will be, can be. When we say can be, that means we will have to report this matter to Juvenile Justice Board. Now, Juvenile Justice Board will assess this boy. They will have a team of psychologists as well. They will basically ask him questions. What is the crime that you have committed? Are you aware of the crime that you have committed? Were you aware of the repercussions of the crime that you have committed? Basically, to judge, to test whether this boy is psychologically mature or not, psychologically adult as well, because today children, they become adults very soon. They mature very soon. So what my generation, would come to know at the age of 18. Today's generation, they come to know at the age of 10. Whether that is exposure to internet or massive exposure to OTTs, that's a separate matter. Even during my childhood, there used to be internet. But the point is, children today mature faster. And when they mature faster, that means this age limit 18 can be brought down. That is how there are people who today talk about age of consent. Age of consent in the sense, age of consent means when can a girl give her consent for a sexual interaction? That age is 18. But if you notice, girls, boys as well, they enter into a relationship at the age of 14, 15, 16, or even before that. And then they also indulge in sexual interactions. But when the family of the girl comes to know about that, they file a rape case against the boy. Although it is a consensual sexual relationship, but a rape case is filed against the boy. Why? Because a girl under the age of 18 cannot give consent. Under the law, her consent is not consent. That is why there are people who are demanding that this age of consent should also be reduced to 16, for example. But be that as it may, this boy in the age group of 16 to 18, if he has committed a heinous crime, can be tried as an adult. But for that, the Juvenile Justice Board will have to assess this boy and decide whether he should be tried as an adult or not, whether he has developed that mental faculty by which we can declare that this child is basically an adult. But this law was passed in 2015, or this law was amended in 2015. These changes were made in 2015. Does that mean this juvenile who committed a crime in December 2012 will be booked under this law of 2015? No. Why? Because that is something which is prohibited by Article 20 of the Constitution. With the assumption that if I would know that I would be sentenced to life imprisonment or I will be sentenced to death if I commit this crime, I may not commit this crime. That's the assumption, that's the hope. So that is what Article 20, Clause 1 talks about. No person shall be convicted of any offense except for the violation of the law in force at the time of the commission of an offense. Now let's look at something else, for example. If, for example, prior to 2015, the maximum punishment is 3 years, but in 2015, the law was changed and the law said this juvenile can be sentenced to life imprisonment as well, not death. That means this child in the age group of 16 to 18, when he commits a heinous crime, he can be tried as an adult, can be given life imprisonment as well, but cannot be given death sentence. Now, assume for a while that this juvenile was caught in 2020. I will write here assumption, otherwise you will think that this juvenile was caught in 2020. Let's suppose, assume for a while that this juvenile who committed a crime in 2012 was absconding, but now he has been arrested in 2020. In 2020, what is the law in force? The law which was amended in 2015. So this juvenile who will be now arrested, although now he's not a juvenile, he's an adult, he's crossed the age of 18. Will this individual be subjected to the amended law of 2015 or the law which existed in December 2012, existed at the time of the commission of the crime? It is this law which will prevail. Because what is the time? When is the time when you committed this crime? At that time, what was the act in force? That act will be applicable to you. And if at that point in time, the maximum punishment was 3 years in a reform home, if later on the maximum punishment changed to life imprisonment, you cannot be given life imprisonment. You can only be given 3 years in a reform home. That's what Article 20, Clause 1 talks about. Article 20, Clause 1 talks about something else. which is similar to no ex post facto laws which we find in the US Constitution. What does that mean? There is civil law, and then there is a criminal law. What is the difference between the two? What is a civil wrong and a criminal wrong? Civil wrong is basically a dispute between two individuals or two parties. For example, marriage, divorce, inheritance, property, land areas. Basically, it is a dispute between two individuals, or for that matter, contract. You and me, we have signed a contract under which I will give you some services, but I'm breaching this contract, violating this contract. Ultimately, what will happen? This will fall under the civil law. This will be a civil wrong. That means primarily civil wrong or civil case is a dispute between two individuals or two parties. But a criminal wrong is a dispute where one party is the state. What state? State under the meaning of Article 12 of the Constitution. One party is the state. For example, it is the duty of the state to protect law and order in the society, to maintain calmness in the society, peace and order in the society. Now, if somebody is committing a murder, this case will be against the state. That means this accused will be fighting against the state because the state will have to convince the court that you have to punish this individual. Why? Because it was my responsibility to ensure peace and order in the society, and this person has violated that. That means it's a dispute between an individual or between a party and the state. The other party is the state. You might ask, sir, if civil wrong or civil case is a dispute between two individuals, what if, for example, there is rape? One person, a male, has committed rape against a woman. So this is a dispute between two individuals. So why should state get involved? Why should the other party be the state? Why should, on behalf of this woman, state file a case? It is because it's the duty of the state to protect the dignity of the woman. Similarly, it is the duty of the state to ensure that there is no untouchability in the society. And if somebody is practicing untouchability, case can be filed against this individual and the other party will be the state. That means a criminal wrong or a criminal case is a dispute between the individual or the party and the other party is the state. Article 20, Clause 1 says, this criminal law can be passed by the legislature, obviously, but it cannot be given retrospective effect. In civil laws, a retrospective effect can be given. What does that mean, retrospective effect? For example, let's assume for a while you have purchased this course, you have bought this course, and there are recordings available of the previous batches as well. All the previous subjects that we have discussed, the recordings are available on the app. You want to access those recordings, but you have joined the class today. How can you access previous recordings? When you will buy this course, purchase this course, we will say that this course will come into effect from 1st of January 2023, which means retrospective effect, which means your course is given effect from a previous date, from an earlier date, which means all the recordings from January 2023 become accessible to you. Similarly, when the laws are passed, For example, when the law is passed related to the Triple Talaq Act, not Triple Talaq, when the laws are passed related to Land Acquisition Act or any civil law when it is passed. For example, taxation. We saw the taxes imposed on gambling, or we saw the taxes imposed on online gambling were given retrospective effect. Or there was a case known as GAR, General Anti Avoidance Rules. It was basically a civilian protection, a civilian matter, a civil matter. It was given retrospective effect. That means this tax or this law will enter into force from a previous date, from an earlier date. But a criminal law cannot be given retrospective effect. If you are passing a criminal law today, you have to give it a prospective effect. This law will enter into force from a later date, or this law will enter into force from today. Because when I committed this act, if it was not a crime when I committed this act cannot be made into a crime by passing a law at a later date. To make it simple, is teaching polity at Byjus a crime? It's not a crime. So right now it's not a crime. If tomorrow it becomes a crime, I'll stop teaching because I don't want to be a criminal. I don't want to violate the law. But what if in 2024 elections, I want to contest elections from the Varanasi constituency against Mr. Modi, and Mr. Modi sees me as a threat? This person can defeat me, is getting a lot of support from the people of my constituency. There is anger against me, and there is support for him. How can I disqualify him from contesting elections? Mr. Modi has the majority in the parliament, will pass a law, a criminal law, amendment to the Representation of the People Act, saying anybody who taught polity at Byjus is ineligible from contesting elections because it is a crime, and this law will enter into force from October 2023, which basically means you are passing a law and giving it a retrospective effect. You are passing a criminal law and giving it a retrospective effect, which basically means although when I was teaching polity at Byjus, it was not a crime, but it was subsequently made into a crime by passing a law at a later date. This cannot happen. That is Article 20, Clause 1, which basically means Article 20, Clause 1 is a limitation on the legislature. What is 20 Clause 1? No person shall be convicted of any offense except if you have violated a law which was in force at the time of your committing that offense. And if at the time of committing that offense, if the punishment was lesser, but later on the punishment got enhanced, you cannot be given that enhanced punishment. You can be given only that punishment which was in force when you committed that crime. And at the same time, legislature cannot enact a criminal law and give it a retrospective effect. Civil laws can be given retrospective effect, but criminal laws cannot be given retrospective effect. That's the limitation on the legislature under Article 20, Clause 1. Any doubt? Criminal law is if you scandalize the court, the judgment of the court, if you deliberately obstruct the implementation of that verdict, that's a criminal contempt. Legislature means any body which is making laws, which means parliament as well, state legislature as well. Same offense more than once. I committed a crime. I committed murder. Matter went to the court. The court was presented with the evidence. And ultimately the court said, yes, you are guilty. You are sentenced to life imprisonment. I was thrown into a jail. I stayed there for 14 years, 15 years, 16 years, 20 years. After that, by looking at my conduct, the government has released me. The prison authorities say that your sentence is over. Just like the rapists of Bilkis Banu. They were sentenced to life imprisonment, but once 14 years were over, you are eligible to be released. Eligible. That means a board will be constituted by the prison authorities. They will decide and see whether this person should be thrown back to the society or not, whether this person is fit to be integrated back with the society or not, is he still a threat to the society or not, things like that. And ultimately, the rapist of Bilkis Banu, their sentence got over and they were released. Once they were released, as soon as they step outside the jail, can they be arrested again for the same rape of Bilkis Banu? No. Why? Because once you have committed that offense, once you have served your time in the jail, for the same offense, you cannot be punished more than once. But here, please understand what is this term same offense. Same offense does not mean if I was convicted for rape, I served 20 years in jail. After that, once I come out of the jail, now I can rape anybody or I can murder anybody if I was serving my time in the jail, because murder is an offense. And for the same offense, I cannot be punished more than once. And if I have been punished once for murder, after that, I cannot be punished for murder again. I can go on killing people. No. Every act of murder is an offense. Which means if you murdered X and if you have served your time in the jail, after you are out from the jail, if you murder Y, that is another offense. That does not mean you can go on killing people. One killing is one offense. If you kill someone else, that's another offense. For the same offense, you cannot be punished more than once. This is based on the maxim nemo debe bis vixari. A man shall not be brought into danger for one and the same offense more than once. And this is similar to a concept in United States which says no double jeopardy. That means you cannot be punished for the same offense more than once. But you might have a question. Here is a terrorist. If you notice that this terrorist, once he is arrested, FIR is filed, charge sheet is filed, and ultimately the case proceedings go on. And if you closely follow that case, you would realize that the judges say this terrorist should be given death sentence. This terrorist should be given life imprisonment as well. This terrorist should be given 10 years jail as well. This terrorist should be given 5 years jail as well. On this terrorist, fine should also be imposed. Act is one. This is an act of terror. You have committed one offense. But why are you punished more than once? Death sentence as well, life imprisonment as well, 10 years in jail as well, 5 years in jail as well, fine as well. Although all these sentences would run concurrently in the sense, if you were given 20 years jail in one case, 10 years jail in another case, 5 years jail in another case, that means it's not that you will spend total 35 years in jail. No. If you are given 20 years in jail, that period will start from today. You are given 10 years imprisonment as well. That will also start from today. You are given 5 years jail as well. That will also start from today. That means together, for the total of 20 years, you will remain in jail. But then why is this terrorist punished more than once for the same offense? No, offense is not one. Offenses are many. For example, this terrorist, through his activities, he has waged war against the country. That is offense one. Through his terrorist activities, he has killed people. Offense number two. He has injured people. Offense number three. He was in possession of arms. That means he has violated the Arms Act. Offense number four. He may have also bought some car and through which you are breaking the traffic signals as well and ramming into a hotel. So you have violated the Motor Vehicles Act as well. That is offense number 5. For every single offense, the punishment is to be given. So for waging war against the country, you are sentenced to death. For committing murder, you are sentenced to life imprisonment. For Arms Act, you are sentenced to 5 years in jail. For Motor Vehicles Act, you are imposed with a fine, which ultimately means that a person is not punished for the same act of violence more than once. No, because the offenses under this act are multiple. And this 20 clause 2 is basically a limitation on judiciary. That means judiciary cannot prosecute and punish an individual for the same offense more than once. How do we say it is a limitation on judiciary? Let's take the example of a civil servant. Or let's take the example of a legislator. When the crime is same of Bilkis Bano and Nirbhaya, why punishment different for the criminal? Because the courts will have to decide what comes under the rarest of the rare cases, which we have discussed yesterday, what constitutes rarest of the rare case. And every act of rape cannot be given death sentence unless and until that act falls under the category of the rarest of the rare case. For example, if you read today's newspaper, today's Indian Express newspaper, I think on page number 5, the Delhi High Court has commuted the death sentence of Batla House encounter convict to life imprisonment, saying this is not the rarest of the rare case. So, an individual, a terrorist who was arrested in the Batla House encounter, which resulted in the unfortunate killing of a policeman as well. This individual was sentenced to death by the trial court. But on an appeal before the High Court said, no, this is not the rarest of the rare case. Your death sentence is commuted to life imprisonment. An example of retrospective civil law, GAR, GAAR, General Anti-Avoidance Rules. Sir, if court gives verdict of 14 years imprisonment plus death sentence, then when will the death sentence be given? After 14 years or immediately? Immediately. You don't have to wait for 14 years to be completed and then you can hang this individual. No, it can be any point in time. Sir, why still no death penalty on cases such as Nirbhaya and Bilkis Banu? In Nirbhaya's case, when there were 6 accused, one accused was a juvenile. He was set free after 3 years in a reform home. One accused, he committed suicide inside the jail. Remaining 4 have been hanged. Death sentence was awarded to them. Does life imprisonment always mean 14 years? No. Sometimes the life imprisonment, Supreme Court says, or the court says, life imprisonment means imprisonment for the normal life of an individual, which means you will never be released. For your entire life, you will have to remain in jail. Sir, can a pregnant woman be hanged? No, she won't be. For her medical reason, her sentence can be commuted. So instead of death sentence, she can be given life imprisonment. Okay, what was I discussing? For example, a civil servant or a legislator, for example. Let's say I am a legislator. I have committed a crime. What is the crime? Let's say Rahul Gandhi. I have committed defamation, criminal defamation, for which the court in Gujarat said, you are guilty, you have to serve 2 years in jail. But for the same act, for the same offense, I was also disqualified from Lok Sabha, although later on Supreme Court reinstated me as the member of the Lok Sabha, saying we are setting aside this conviction. But be that as it may, assume that this matter did not reach the Supreme Court. Assume we are at a high court stage. A high court in Gujarat says, Rahul Gandhi, you are guilty of committing criminal defamation and you are sentenced to 2 years in jail. Defamation, I told you yesterday, can be civil as well, can be criminal as well. That is why in 2014, Dr. Subramaniam Swamy, he approached the Supreme Court and asked the Supreme Court, why should defamation be a criminal act? That doesn't mean you can defame me. But Dr. Subramaniam Swamy's whole point was, why should state get involved in protecting my reputation? I can protect my own reputation. I can arrange my own lawyer to file a case against you. Why should state get involved? Why should it be a crime against the state? For that, we need to understand that this defamation is basically a product of the colonial laws. During the colonial period, during the British period, if you are defaming me, I'm a public servant. If you are defaming me, I'm an important public figure. You're not basically defaming me, you're basically defaming the crown, the British crown, because I represent the British crown. So British crown will defend this person's reputation at all times. So if somebody is defaming this individual, the crown will enter into the picture and will defend his reputation. That was the logic. But even in Britain, defamation now is not a criminal case, is not a criminal wrong, it's a civil wrong. So if Arvind Kejriwal has defamed Mr. Modi, state should not get involved. Let Mr. Modi and Arvind Kejriwal fight it amongst themselves in the court of law. Let it be a civil dispute between the two individuals. That was the logic given by Dr. Subramaniam Swamy before the Supreme Court, but Supreme Court said no, defamation will remain both civil as well as criminal wrong. Unless and until Parliament decide to repeal defamation as a criminal wrong and retain it only as a civil wrong. But be that as it may, Rahul Gandhi has committed criminal defamation, for which he was sentenced to 2 years in jail. Now the same offense, because he defamed the Modi caste, for the same offense, he was disqualified by Lok Sabha as well. So is that not violation of Article 20 Clause 2, which says no person shall be prosecuted and punished for the same offense more than once? But Rahul Gandhi is prosecuted and sentenced for the same offense more than once. Once, sentenced to 2 years in jail. Second, disqualified from Lok Sabha. No, it is not. Why? Because this 20 Clause 2 applies to judiciary. Judiciary cannot prosecute and sentence you for the same offense more than once. Just like 20 Clause 1 applies to legislature. Legislature, whether it's a state legislature or the parliament, cannot enact a criminal law and give it a retrospective effect. Legislature cannot pass a criminal law today and say that this law will come into force from 1st January 2000 or 1st January 2021 or 1st January 2023 cannot be given retrospective effect. Similarly, 20 Clause 2 is binding on the judiciary. Judiciary cannot prosecute and sentence an individual for the same offense more than once. Clear? Very good. Then we have 20 Clause 3, which is similar to the Fifth Amendment to the US Constitution, which provides that no person shall be compelled in any case to be a witness against himself. How many amongst you have, this is the example that I got just now in my mind, how many amongst you have watched a movie, Shawshank Redemption? A lot of people. Towards the end of the movie, when the police comes to arrest the warden as well as the other individual, when the other individual is to be arrested, the police comes and says, you have the right to remain silent, but any word you utter will be used against you. which primarily means that in United States, also in India, nobody can be forced to become a witness against himself. If this 20 clause 3 was not present, the police would solve all the cases, even if you are solving them wrongly. How? A bomb blast took place outside this hotel. For example, I am teaching you right now, the police comes and arrests me. You have committed this act of terror. But I have not. I was teaching polity at Byjus. In fact, I was teaching 20 clause 3. No, you have committed this crime. Accept that you have committed this crime. How will I accept? I have not committed this crime. What are you saying? I know the law. I will drag you to the court. And then one slap, some little bit of torture, my nails are lifted, chili powder is thrown on it, an iron is taken, and this hot iron is pushed against my face. I'm basically tortured. What would I say? Please don't do this further. I am accepting that I've committed this crime. I'm confessing to this guilt. And when I say yes, I've committed this crime, this document will be presented to the court. The court will say, yes, you have accepted that you have committed this crime. So you are guilty. Sentence him to life imprisonment or sentence him to death. This cannot happen because by this logic, the police can solve all the cases, even if you are solving them wrongly. Even if the guilty is X, but you are forcing Y to accept the guilt and sentence this individual. To make it even more clear, 20 clause 3 is binding on the executive. 20, how many organs are there in the state? Legislature, executive, judiciary. 20 clause 1 is binding on legislature. 20 clause 2 is binding on judiciary. What is the other organ left? Executive. 20 clause 3 is binding on the executive. That means when we say no person who is accused of any offense shall be compelled, shall be forced to become a witness against himself. This applies to executive, which means the police will have to independently collect evidence and prove that I have committed this crime. I cannot be forced to become a witness against myself. Sir, but sir, we watch in movies something known as confession. People confess to their crimes. First, stop watching Bollywood movies. If at all you want to watch good ones. And even if you watch these movies, you should get this sense that you should not trust them with all the facts. So when the Bollywood movies show that an individual has confessed to his crime and the court accepts that or the police accepts that confession and bases that confession that individual is prosecuted, it is not entirely true. Why? This confession, if given to police, is not valid. But if this confession is given before a judge, it becomes valid. What does that mean? Afzal Guru, he was accused of plotting parliament attack in 2001. He was arrested. When he was arrested, the concerned ACP brought him before the media, and before the media, he confessed to his crime. He talked about how the conspiracy was hatched in Pakistan, how there was one terrorist, Ghazi Baba, who basically gave him money and funds to travel to Delhi, plot this attack, and how he was in touch with 5 other attackers, how he bought the ambassador car for them, how he bought the SIM cards for them, so on and so forth. So basically, he revealed everything before the media. And when this confessional statement, because he gave this confession before the police that yes, I've committed this crime, yes, I plotted this attack, yes, I got this much. When this confession was brought before the judge threw it away. Said, what rubbish. This confessional statement given to the police is not valid because 20 clause 3 applies. But if this confessional statement is given before the judge will ask questions to this individual. Did somebody force you from giving this confessional statement? Don't worry, you can tell me now, I will take care of it. If the police has forced you, if the police has tortured you, we will suspend them. We will send you to a different jail. We are here to protect you. But please tell us, are you giving this confession out of your own free will, or if there is a force involved? If there is force involved, this confession is not valid. Because you should not be compelled, you should not be forced to become a witness against yourself. If voluntarily you're accepting your guilt, you're giving that confession to the judge, it becomes valid. But then, what about some tests, such as polygraph, brain mapping, narco analysis, lie detector, DNA fingerprinting? What about all these tests? For example, Arushi Talwar case. I think she was a ninth class student in Noida. Both the parents were dentists. There was one helper in the house as well. And suddenly, one fine morning, the husband and the wife, they find out that their daughter has been murdered. Her throat has been slit. Quickly, the finger pointed at the domestic help. They thought that it's the domestic help who is responsible for this, Himraj. But then, very next day, even this domestic help's body was found at the terrace of this house. Sensational case, way back in 2009, I think 2008, 2009. There was so much media attention on this that ultimately this case got shifted to the CBI, the Central Bureau of Investigation. And even today, we don't know who killed Arushi Talwar. Why? Because it was thought initially that it would be the parents. Why? Because parents are in one room, the child is in the other room, and the house is locked from inside. There is no evidence which shows that somebody forced inside the house, and the manner in which the throat of the girl was slit, it could have been done only by a professional using a doctor's knife. Since the parents were also doctors, there were a lot of assumptions made, and ultimately it was argued that it is the parents who committed this crime. And ultimately, parents were sentenced to life imprisonment. But then, when the reinvestigation took place, the court set them free. Why? Because I told you previously that when you are accused of any crime, it should be proven beyond any reasonable doubt. Even if there is a reasonable doubt, you will be set free. Because it is okay to let go 5 criminals, but you should never punish even a single innocent. That's the golden rule of criminal justice system. But be that as it may, both the parents were sentenced to these tests: lie detector test, brain mapping, narco analysis, polygraph, so on and so forth. In fact, if you read the recent interview of Bonnie Kapoor, the husband of the late actor Sridevi, who unfortunately passed away in Dubai, I think, at a hotel, he says, I was subjected to lie detector test for 48 hours because there was a lot of media scrutiny on this case. Some people thought that there is something fishy in this entire episode. Maybe I killed my wife, but I was subjected to lie detector test for 48 hours, and ultimately it came out that I'm innocent. I have not committed this crime. Basically, it was a natural death. But be that as it may, all these tests, what is the validity of these tests? What if I am forced to take the lie detector test? And what happens in these tests? Basically, some chemicals will be injected into my bloodstream. When some chemicals will be injected into my bloodstream, I will lose some sense of my consciousness. I will enter into a subconscious state. And when questions will be asked in this subconscious state, I will give the right answer. Why? Because if you are conscious, then you consciously decide to lie. When you are in a subconscious mind, whatever is the reality, you will come out with that reality. Or your heartbeat will be measured, the pulse will be measured. Whenever you will lie, the lie detector test will see a spike, because when you are lying, there are some changes that take place inside your brain, inside your bloodstream. Those are captured. Scientific. Those are captured, and then the test says that you have lied. Whatever the result of these tests, can these be used or as an evidence? 20 clause 3 says, no person accused of any offense shall be compelled to become a witness against himself. I am accused of Arushi Talwar murder. I am the father of Arushi Talwar. Now I am forced to, compelled to take lie detector test. When I take the lie detector test, whatever is the result of this lie detector test, can it be used as an evidence? Because now I am a witness against myself. Or DNA fingerprinting, for example. There was a murder at a hotel. Now there is forensic team that is part of this crime scene. They try and collect some evidence. They see that there is a glass of water, or they see that there is a liquor glass. You basically take that glass, you look for fingerprints, and then you force me to give my fingerprint, because they will have to match my fingerprint with the fingerprint on that glass, which basically means I was present at that scene of crime, which basically means that circumstances tell that I am guilty of committing this crime. Will I be forced to give my fingerprinting? Initially, it was thought that all this is valid. But then, after the Arushi Talwar case, a case was filed, Shelby versus State of Karnataka 2010. Supreme Court said involuntary admission of these scientific tests. Involuntary means you are being forced to, it's not voluntary. You don't volunteer to take these tests, you are being forced to take these tests. Involuntary admission of these tests is unconstitutional. Why? Because it violates Article 20, Clause 3. You cannot be compelled to become a witness against yourself. And it violates the right to privacy as well. How right to privacy? When chemicals are injected into my bloodstream, when I go into the subconscious state, questions are asked. Maybe I will reveal not only the things related to this case, but some of the intimate details about my life. That means you are intruding into my privacy. This right to privacy is getting violated because of these tests, and that is how all these tests are unconstitutional. Except DNA fingerprinting. Why? Now listen to me carefully. If somebody tells you you cannot qualify this exam, and tells you cannot qualify this exam repeatedly, day in and day out, there will surely come a time where you will also believe in it that I cannot clear this exam. There is a forest in some areas in Africa, South America, where if you have to cut down trees, you don't use axes and other equipments. There are tribals who go surround that tree, swear on that tree, shout at that tree, and ultimately the tree collapses after some time. I am not a murderer, but when the police enters the jail where I am locked up, tortures me, and tells me repeatedly that you are a murderer, you're a murderer, you're a murderer, this enters into my subconscious state as well. So when in the lie detector test, I am asked, are you a murderer? I say yes. Not because I am, but because I am forced to say I am through my subconscious mind. But DNA fingerprinting, the results would always be the same. If I am forced to take a lie detector test and inside the jail I was tortured and I was told you are a criminal, you are a criminal, you are a criminal, the result of this test would be different. I will say I am a criminal. But if I am voluntarily giving this test, I know I have not committed this crime. I am volunteering. Take the lie detector test, I will prove my innocence. And the question is asked, are you a murderer? I say, no, I am not. Because nobody is forcing me to take this test. I'm doing it voluntarily. So the result of this test would vary depending upon whether you were compelled to take this test or you did it voluntarily. After all, these findings are not scientific enough. There is still a lot of work that you'll have to do to make it accurate. But DNA fingerprinting, where if you are forced to give us this fingerprint, or if you do it voluntarily, doesn't change the outcome. It doesn't change the result of this test. The result will remain the same. That is why DNA fingerprinting is allowed. But these tests are unconstitutional if forced on an individual. But if you still want to perform these tests, you have to take the permission of the High Court. And then even the results would not be treated as evidence. Then what is the purpose of carrying out and conducting these tests? You're saying even if police says it is necessary that we have to perform lie detector test on this accused in this case, you can't force it. If voluntarily he is agreeing to a lie detector test, that's another matter. But you can't force. But if you still want that it is necessary to perform this lie detector test, you have to take the permission of the High Court. High Court, please allow us to perform this lie detector test because this seems like a very closed case. We have no leads whatsoever. We need to perform this lie detector test. Please allow us. If the court is convinced, the court will allow you. With a rider saying no, even if you perform these tests, the results of these tests will not be used as an evidence. Then what is the purpose? Even if these tests, the results would not be treated as an evidence, but these test results would lead to evidence. Evidence in the sense, I was compelled to take this lie detector test on the orders of the Bombay High Court. Whatever I say in this test will not be used as an evidence, but we will get some clues. Okay, are you a murderer? Yes, I am. Where were you at the time when this murder took place? Where were you on Sunday at 10 a.m. in the morning? Get the clues. Where is the murder weapon? It is hidden under a park tree. Where are the blood-stained clothes of the victim? So basically, when you get the clues from this lie detector test, you go to that park and you take out the murder weapon. You go to another location and take the blood-stained clothes. This knife, this item which was used to kill an individual, this murder weapon, blood-stained clothes, now they are matched with the DNA fingerprinting. Now evidence is collected. So it is these things that you have extracted after that lie detector test. Those will be used as an evidence. So you are taking these lie detector tests to get clues so that through these clues you can lead towards the evidence. Long story short, Article 20 talks about three things. There are three clauses under Article 20. 20 clause 1 is binding on the legislature. 20 clause 2 is binding on the judiciary. 20 clause 3 is binding on the executive. 20 clause 1, legislature cannot enact a law, a criminal law, and give it a retrospective effect. If you have committed a crime today, what was the punishment for this crime? Same punishment will be given to you. But if in 2 years later the punishment changed, punishment got enhanced, you cannot be given that enhanced punishment because you can be sentenced to the law which was in force at the time of committing that offense. Similarly, 20 clause 2 is binding on the judiciary. Judiciary cannot prosecute and sentence and convict a person for the same offense more than once. And 20 clause 3 is binding on the executive. No person, just like the Fifth Amendment to the US Constitution, which says no person shall be compelled to become a witness against himself, which means the executive has to independently conduct the investigation, come up with the evidence, and that evidence can be used against me. But then what is the validity of these tests such as lie detector, brain mapping, polygraph, narco analysis? They breach privacy. They violate privacy. They violate Article 20, Clause 3. But if you still want to perform these tests, if it is absolutely necessary, you have to take the permission of the concerned High Court. Even then, the results would not be treated as evidence, but maybe you will get some clues. For example, in Sheena Bora murder case, we got some clues through these tests. And what is that Sheena Bora murder case? We don't have to get into that, irrelevant for the exam. But what about DNA fingerprinting? That is constitutional, that is okay, because the results of these tests, DNA fingerprinting, would not change whether you are forced to take this test or you do it voluntarily. That is Article 20 of the Constitution. Any question? Does confession before the executive magistrate is valid? No, it's not valid. It has to be before a judicial magistrate. Sir, why even after taking these tests, judiciary is not doing its work speedily? For example, Shraddha Walker murder case. Uh, Judiciary is also unfortunately overburdened with a lot of work. It's not that they have to deal with only one case. There are thousands of other cases which does not have the media spotlight on them. Those are also to be addressed. That is why we will discuss in judiciary that we need to increase the number of judges. Jail is an exception, bail is a norm. Explain, sir, again. I did not explain it even once, so how can I explain it again? When the time comes, I will explain. Then if there is a requirement, I will explain again. Not now. Income tax laws are retrospective, can be retrospective. It's a civil matter. Yes, there are exceptions also. For example, in uh, cases under the PMLA, Prevention of Money Laundering Act, if you give a confession before the executive, that is also valid. But those are exceptions. We will discuss these exceptions when the time comes in the subsequent classes. Right now, whatever you have to understand, we have discussed. Heinous crime, a crime for which the minimum punishment is 7 years. If the person is not punished again for the same crime, then why does he crime again? This should change. My dear, if I have committed a crime of murder, I have murdered X, for which I was sentenced to jail. For the same murder of X, I cannot be prosecuted again because this person X is dead. How can I murder this dead person again? Clear? But if you murder another person, you will be prosecuted because that's another offense. Let's say, for example, I committed theft in your house, for which I was sentenced to 4 years in jail. Once I'm released, I am committing theft in your house again. It becomes another offense and I will be prosecuted again. Clear? Sir, please reply. If the criminal wears hand gloves, then what is the use of fingerprints? That is why don't watch Bollywood movies. Clear? Okay. Article 21 of the Constitution, protection of life and personal liberty. Article 21 is considered to be the backbone of Part 3 of the Constitution, one of the most important fundamental rights. What does Article 21 say? No person shall be deprived of his life or personal liberty except according to the procedure established by law. No person, which means Indians, citizens, as well as aliens. No person shall be deprived of his right to life or liberty except according to the procedure established by law. And what is this procedure established by law? We will discuss slightly later. But first, what's the meaning of this term life and personal liberty? This is where we see the beauty of judicial creativity. The Supreme Court has said that right to life does not mean physical act of breathing alone. That means you're allowed to breathe. That means you're enjoying right to life. No. Right to a meaningful life is what Article 21 exactly means. And that is how Supreme Court has expanded the scope of right to life and has given us these fundamental rights which originally were not part of the Constitution. For example, in series of judgments, Supreme Court has said right to life means right to live with human dignity. How can you enjoy a life, a meaningful life, if the air around you is polluted? Right to a decent environment is also your fundamental right under Article 21. How can you enjoy life unless and until you have some means of livelihood? Right to livelihood becomes your fundamental right. How can you enjoy a meaningful life if you do not have a shelter? Right to shelter is also your fundamental right. How can you enjoy the life of liberty when you don't have privacy? Inside the four walls of your home, nobody should be able to tell you what to eat, what to drink, how to dress, whom to make love to. This should not be the domain of any other entity. This right to privacy is also a fundamental right. How can you enjoy a meaningful life if you don't have a good health? Providing good healthcare facilities, providing insurance to you, that is also becoming a fundamental right. I have right to life, but this right to life is snatched. Snatched in the sense, I am accused of a particular crime. This case should not go on forever and ever and ever. Because I want to quickly clear my name as well. I'm not guilty, I'm innocent. I have a right to speedy and fair trial. That is also my fundamental right. Right to travel abroad. Because if I have the liberty, I should have the liberty to travel abroad, see the world. That is why I told you yesterday, this right of movement, that you can move freely throughout the territory of India, this comes under Article 19. But if you want the right to travel abroad, that comes under Article 21. Right against solitary confinement. If you are guilty of a particular crime for which you are sentenced to jail, inside the jail, you should still be allowed to meet others. You should not be kept in solitary confinement. where you cannot meet and see and interact with anybody. All these are fundamental rights, inferred rights under Article 21 of the Constitution. That is why we say Article 21, the most evolved fundamental right. The highest number of inferred rights had been conferred on the people of this country by the Supreme Court using judicial creativity. But obviously, this right is not absolute, because your right to life, your liberty can be snatched, but only according to the procedure established by law, which we will discuss later. Why? Because if you have right to life, but you snatch the life of someone else, your life should also be snatched. 100%. Otherwise, if you have right to life, which is an absolute fundamental right, which means under no circumstances can your right to life be snatched. Can you be arrested? Can you be detained? By that logic, you will go on killing people, snatching their lives, and nothing will happen to you? No. That is why this right is not an absolute. There are exceptions under which your right to life and personal liberty can be snatched. But what is the significance What is the significance of Article 21 of the Constitution? Let's assume for a while that Article 14, which talks about a right to equality, is absolute. We discussed exceptions to Article 14. We discussed exceptions to Article 15. We discussed exceptions to Article 16. We discussed exceptions to Article 19 as well. Let's assume all these fundamental rights are absolute. You have an absolute, without restrictions, fundamental right. Say whatever you want to say, express whatever you want to express. You have an absolute freedom of speech and expression. You have an absolute fundamental right, which means you cannot be discriminated on any ground, except there is no Article 21. All the fundamental rights are absolute, but you don't have Article 21. You don't have right to life. Can you enjoy any of these fundamental rights if you don't have right to life? That means at any point in time, you can be thrown inside the jail. And inside the jail, you have the freedom of speech and expression. Inside the jail, say whatever you want to say, express whatever you want to express, but there is no audience. It is Article 21 which makes enjoyment of all other fundamental rights possible. Because without right to life, all other fundamental rights become meaningless. You have the freedom to practice your religion, which we will discuss today. You have a fundamental right to practice your religion, but you don't have right to life. You are thrown inside the jail, and inside the jail you are saying, now you can pray to your God. You cannot enjoy other fundamental rights. The enjoyment of other fundamental rights becomes impossible if you don't have right to life. That's the significance of Article 21. And that is why we say Article 21 is the backbone of Part 3 of the Constitution. Assume something else. Assume there is no Article 14, there is no Article 15, there is no Article 16, there is no Article 17, there is no Article 19, there is no fundamental right. Only one fundamental right. Article 21. Right to life and personal liberty. If the judiciary has employed judicial creativity, has expanded the scope of Article 21, has provided us with these and many other fundamental rights which originally were not part of the Constitution, don't you think the same judiciary will say right to life is impossible if you don't have right to equality? Right to life is impossible if you don't have right against discrimination, because you can't enjoy a meaningful life. Right to life is impossible if you don't have freedom of speech and expression. That means even if no fundamental right was provided, except Article 21, every other fundamental right would have been granted to us by the judiciary. That is Article 21 significance. That means if all fundamental rights were absolute, but there is no right to life, all these rights become meaningless. Their enjoyment becomes meaningless. Conversely, if there was only Article 21, no other fundamental right, we did not even need these fundamental rights, because the judicial creativity would have told us that all these rights are inferred from Article 21. Right to life and personal liberty. No person shall be deprived of his right to life and personal liberty except according to the procedure established by law. Which means when we now understand what is right to life, we also need to understand that this is not an absolute fundamental right, because your right to life or personal liberty can be snatched, but only according to procedure established by law. And what is this procedure established by law? Which we have borrowed from the Japanese constitution. Assume for a while that you are accused of a particular crime. You are accused of violating a particular law. Let's say, for example, the police enters the studio, I am arrested, which means Article 21 is violated, or this is a case of Article 21. Whether the police has violated or not, that we will see later, but this is a case of Article 21. If I think that my Article 21 has been violated, where do I go? I go directly to the Supreme Court, because the Supreme Court is the protector of my fundamental rights, is the guarantor of my fundamental rights. Will the Supreme Court interfere and restore my fundamental rights or not? For that, the court will perform three tests. Test number one, there must be a law justifying interference with the person's life or personal liberty. There has to be a law. What does that mean? The police entered the studio, takes my custody, throws me inside the jail. My lawyer approaches the Supreme Court. My lord, my client's fundamental right has been violated. What fundamental right? Article 21. Oh my God, please come. Please set him free. We can't set him free like this. First, we have to perform a test, a triple test. Test number one, there should be a law which should justify this person's arrest. Karnataka police, come here. Why have you arrested this individual? Sir, we have arrested him because he was teaching polity at Byjus. Really? Is there a law which says teaching polity at Byjus is a crime for which you can be arrested? No. No, tell me, is there a law? No. Then how dare you arrest this individual? You're set free. Please go and start teaching polity again. Because there has to be a law. If there is no law which justifies my arrest, which basically means if I have not violated any law of land, why should I be arrested? There has to be a law. Second, this law should be valid. Valid in the sense, the police enters the studio, takes my custody. I approach the court. The court is asking, is there a law which says teaching polity at Byjus is a crime? Yes, sir, there is a law. The law has been passed today by the parliament. Okay, very good. But you have arrested this individual 10 days ago. Right, sir. So when 10 days ago he was teaching at Byjus, at that time there was no law. Although there is a law now, but this law was not valid 10 days ago. We are setting this person free. Or valid law basically also means We have distribution of powers. Powers are divided between union list and state list and concurrent list. Clear? For example, union list, we have defense, we have external affairs, we have communication. Communication, for example, post and telegraph, mobile telecommunication, ports, highways. State list, for example, agriculture, gambling, law and order, police. Concurrent list, for example, marriage, divorce, so on and so forth. What if, for example, Karnataka Legislative Assembly passes a law and through this law says if you use a smartphone and through this smartphone you are basically dealing with enemy state or sending money abroad, you can be arrested. No person shall be deprived of his right to life and personal liberty or personal liberty except under the procedure established by law. What does that mean? That means right to life is not absolute. What is right to life? We have discussed that, but right to life is not absolute. It can be snatched, but only according to the procedure established by law. And how do we say whether the procedure established by law has been followed or not? If you have been arrested, you can approach the Supreme Court. Supreme Court will perform 3 tests. Test number 1, there has to be a law which justifies person's interference with his liberty, with his freedom. If there is no law, you can be set free. Law has to be there because in absence of the law, you cannot be arrested. The example that I gave you, since there is no law which says teaching polity at Byjus is a crime, and I am arrested under that law, but there is no such law, basically I will be set free. But if this law exists, if there is such a law, for example, Karnataka legislature passes a law saying if you are using a computer device, if you are using a smartphone, and through that you are dealing with the enemy state, you are transferring money abroad, it is a crime for which you would be arrested. I was arrested under this law passed by the Karnataka Legislative Assembly. I approached the Supreme Court. My lord, my fundamental right has been violated. What fundamental right? Article 21. Really? Please come. You have to be first arrested under a law. Karnataka state, is there a law which justifies his arrest? Yes, sir. Karnataka legislature has passed a law. Test number 2 will be prescribed. Is this law valid? I will tell the police, I will tell the court, sir, this law is not valid. Why do you say this law is not valid? Sir, this law is passed by Karnataka Legislative Assembly, but this encroaches upon the powers of the Union Parliament. This is not a valid law because Karnataka Legislative Assembly is not competent in passing this law. This law or this matter is not within the competence of the state legislature. Why? Because the state legislature can pass a law on law and order, police, agriculture, gambling, so on and so forth. But the Karnataka legislature cannot make a law under communication because that's the power of the parliament. If such a law should have existed, Such a law could have been passed only by the Parliament of India, not by the state legislature. So, since state legislature is not competent to pass a law under a subject which is under the union list, which basically means this law is not a valid law. It's an invalid law because legislature is not competent in passing that law. If the court agrees, the court will set me free. Yes, you have been arrested under a law, but unfortunately, and fortunately for you, that law is not valid. Now, let's assume that there is a law which justifies my arrest because I violated this law for which I was arrested. What if this law is valid as well? But the condition number third, the test number 3 that will be prescribed by the police, by the court, will be, is the procedure laid down in the law strictly followed or not? Strictly followed in the sense, I am arrested under a law. The police has filed the FIR. Now the police has to file a charge sheet. What's the difference? FIR is the first information report. First information report in the sense that we have the information that this person has sent money to Pakistan, or this person has brought money from Pakistan, hawala money, unaccounted money, and this money is used to fuel terror activities in India. We have this information, and this first information report will name me, that we have the initial information that this person is responsible. But then the police has to conduct investigation, find out evidence, and all these evidences will be collected together and will be part of the charge sheet. Now, sir, dear court, this is the charge sheet. These are all the evidences against this individual. These are all the charges. Charge sheet should be filed within 60 days, for example. Because if the police knows I have committed this crime, let them prove it. Let them at least file a charge sheet. Then I can contest this charge sheet. If you have mentioned in this charge sheet that I was present in Bangalore taking this money from a person coming from Pakistan, if I can prove that on this date I was not in Bangalore, which basically means I will be set free. But first you file the charge sheet. If within 60 days you are not filing the charge sheet, which is the procedure under law, what will happen? The court will set me free. Although you were arrested under a law, although that law is valid as well, but the procedure has not been followed. They should have submitted the charge sheet within 60 days. But since this charge sheet has not been filed, we are setting you free. That means all these 3 tests will be performed by the court. And once these 3 tests are satisfied, the court will say whether your arrest is rightly justified or your arrest is unjustified. That is procedure established by law. That means if these 3 conditions are satisfied, you are rightly arrested because the procedure which is established by law has been strictly followed. No person shall be deprived of his right to life or personal liberty except according to the procedure established by law. What is this right to life? We have discussed. But this right to life is not absolute. It can be restricted. It can be snatched, but only according to the procedure established by law, which we have borrowed from the Japanese constitution. And what is that procedure established by law? If you are arrested, which means your right to life is involved, you say your right to life has been wrongly snatched, violated, approach the court. If there is a law which justifies your arrest because you have committed a crime which violates a law, then test number 1 is satisfied. This law should be valid as well. And third, the procedures mentioned in the law should be strictly followed as well. If these 3 tests are performed, the court will say your arrest is justified. But there is a problem. What is the problem? If Karnataka Legislative Assembly passes a law, or if the Parliament of India passes a law saying anybody who teaches polity at Byjus is a crime and this person should be sentenced to death. This is the law. And the charge sheet in this case should be filed within 1000 years. This is the law. What will happen? I am teaching polity right now. There is a knock at my door. Come. And I am dragged outside the studio. I am thrown into a jail. I go to the judiciary. My lord, my Article 21 has been violated. I said, how? Karnataka police, come here. Is there a law which says this person should be arrested? Yes, sir. There is a law passed by the Karnataka legislature which says teaching polity at Byjus is a crime. Is this law valid? Yes, sir. This law is valid since 2020. We are in 2023. He has committed this crime in 2023. That is why we have arrested him. Are you competent to pass such a law? Yes. On law and order, we have the right to make a law. So these polity teachers at Byjus, they violate law and order by giving inflammatory speeches inside the studios. To maintain law and order, we have the right as a Karnataka legislature to pass such a law. So we are competent to pass such a law. So there is a law, the law is valid as well. But when are you going to file the charge sheet? Sir, according to the law, the charge sheet should be filed within 1000 years. I'm sure before 1000 years, we will file this charge sheet, which basically means I will remain in jail forever and ever and ever without even a trial. Because the trial will start once charge sheet is filed in the court. But according to procedure established by law has been followed. Even if this law is bad, even if the law is horrible, even if the procedure mentioned in the law is unfair, unreasonable, unjustified, the courts are helpless. They cannot give me protection. Because the procedure established by law has been followed. But if it was United States of America, where instead of procedure established by law, we follow due process of law, that means apart from the three tests that are performed by the judiciary, fourth test will be performed in United States. I am arrested. If instead of teaching here in India, I would have been teaching United States, I will say United States Supreme Court. What, my dear? My fundamental right under Article 21 has been violated. Don't worry, come here. Is there a law which justifies the arrest? Have you violated any law? Yes, there is a law passed by Karnataka Assembly which says if you teach polity at Byjus, you are a criminal. Okay, there is a law. Very good. Question number 2, is this law valid? Yes, Karnataka legislature is competent to pass a law on law and order. They have passed such a law under law and order. That means it is valid, I think. Plus, this law is valid. That means it is in force. It's not that this law will enter into force in 2025, because sometimes the effect of the law is prospective as well. This law will enter into force from 2025 at a later date. So if this law would enter into force in 2025, but I was arrested in 2023, it basically means you have been arrested under an invalid law. One more example, for example, if you have been arrested under Section 66 capital A of Information Technology Act, I used an electronic device to transmit a message which causes annoyance to somebody. That's what Section 66A is. I am arrested under this law. So am I arrested under a law? Yes. What is the law? Information Technology Act. Is this Section 66A valid or not? The Supreme Court in 2015 in Shreya Singhal case said Section 66A is unconstitutional because it violates freedom of speech and expression. So I am arrested under Section 66A, which is part of the law. But this law is not valid because the law has been declared invalid by the judiciary. So I will be set free. But if I am arrested under this law, which says teaching polity at Byjus is a crime, this law is valid as well. The procedure says that this charge sheet should be filed in 1000 years. Even that procedure has not been violated because it's still first year. I have to survive 999 more years for the charge sheet to be filed. But the United States judiciary will say, forget about these three things. Let's perform test number 4. Is this law just? Are the procedures mentioned in the law reasonable or fair? That means in this due process of law, the courts examine The intentions of the legislature. Legislature has passed a law, but the law is bad, horrible law. That means your intention is bad. This law is unconstitutional. This person is set free. For example, Lawrence versus the state of Texas, 2003. Act of homosexuality was considered a crime in the state of Texas. And there were two men who were arrested under the homosexuality law, and they were charged with sodomy. If it was India, for example, you are arrested. Is there a law which says that whatever you have done is a crime? Yes. Is this law valid? Yes. Are the procedures mentioned in the law followed or not? Yes. You are to be arrested. Remain in jail. Rot in jail. But when this matter reached the Supreme Court of United States, the US judiciary said, is there a law which says you have committed a crime? Yes. Is this law valid? Yes. Are the procedures mentioned in the law followed or not? Yes. Now let's go into the intention of the legislature. How can you enter into the private bedroom of two consenting adults? Stay away from it. Stay away from the personal, intimate lives of the people. That's not your job. That's not your role. How dare you pass such a law which violates the privacy of individuals? What they do inside the four walls of their home is none of your business. Stay away from it. And the courts in United States, since they follow due process of law, which means they perform test number 4 to see if the law is fair, just, reasonable. Are the procedures reasonable? If not, the court will set you free. That is due process of law. In India, what do we follow? Which basically means procedure established by law protects you against the executive. If the executive has arrested you without any law, if the executive has arrested you under an invalid law, if the executive has not followed the procedures mentioned in the law, the court will come to your rescue and set you free. But the courts are helpless when it comes to procedure established by law while dealing with the legislature. Because what if the legislature has passed a bad law, a horrible law whose procedures are unreasonable, unjust, unfair? The courts will not come to your rescue. Procedure established by law. But United States says we should protect our citizens not only from executive but from the onslaught of the legislature as well. So apart from these three tests, we will perform test number 4. Legislature, are your intentions clear? Is your law just? Are the procedures reasonable, fair? Matter went to the court in India in 1950, A.K. Gopalan versus State of Madras. Basically, it was a case under which A.K. Gopalan, who was a communist leader, he was kept under surveillance. Even at night, his house could be searched and frisked by the police. He said, I have right to life and personal liberty. I should not be disturbed at night. He approached the Supreme Court, but Supreme Court said there is a law which allows the state to even frisk and search your house at night. We cannot offer you any protection because we follow protection against the executive, but we cannot protect you against the legislature. We follow procedure established by law, not due process of law. Matter went to the court again, the very infamous ADM Jabalpur versus Shivakant Shukla. 1975, emergency was imposed. And during emergency, a law was passed known as MISA. Maintenance of Internal Security Act. Under this law, almost the entire opposition was arrested because we have to maintain internal order. Student activists, student leaders were arrested. Lalu Prasad Yadav was also arrested. Lalu Prasad Yadav's wife was expecting at that time. And during the incarceration of Lalu Prasad Yadav, while he was still in jail, a baby girl was born, and baby girl was named Misa Bharti. Maintenance of Internal Security Act. And under this law, it basically said no habeas corpus. Habeas corpus, which we will discuss tomorrow on Monday. If your fundamental right has been violated, if you have been wrongly arrested, detained by the police, you can file a habeas corpus petition before the Supreme Court. Habeas corpus basically means show me the body. For example, I am arrested. Lalu Prasad Yadav has been arrested. Rabri Devi approaches the Supreme Court. My husband has been wrongly detained. Please save his fundamental right because you are the protector of fundamental rights, my lord. The court will ask the state government or will ask the central government, show me the body. Bring Lalu Prasad Yadav before us so that we can ask him whether you were rightly arrested or wrongly arrested. If we are convinced that he was wrongly arrested, we will set him free. So this right to approach the court, at least this right is there that you can approach the court and file a petition of habeas corpus. This MISA Act says there is no habeas corpus during emergency. When emergency is imposed, people cannot even approach the court and file a habeas corpus petition. Matter went to the court. ADM Jabalpur versus Shivkant Shukla. My lord, can I not even approach the court if my fundamental rights are violated? That's what MISA talks about. This is a draconian law under which writers, activists, opposition leaders, student leaders, trade union leaders, all of these individuals are arrested. That is how in 1975 June, when emergency was imposed, the newspapers next day read Vajpayee, Ashok Mehta, JP arrested. Supreme Court said, is there a law which justifies your arrest? Yes, MISA. Is this law valid? Yes, because this law is in force. Parliament is competent enough to pass this law. Are the procedures mentioned in the law followed or not? Yes. Then we are helpless. We cannot protect you. We cannot safeguard you. Sir, but even habeas corpus is suspended. So what? We cannot protect you from against the legislature. If the executive has violated your rights, we can safeguard you. But we cannot protect you against the actions of the legislature. Sorry, because we follow procedure established by law. This was in 1976, which is considered to be the stain on Indian judiciary. There was only one judge. It was basically a 5-judge bench. Four judges said, yes, MISA is valid. Even during emergency, you cannot approach the court. There was one judge who dissented. Justice Khanna. Justice Khanna was later eligible to become the Chief Justice of India as well. But he was not appointed as the Chief Justice. Someone else was appointed as Chief Justice by the Indira Gandhi government, which we will discuss in judiciary. But 2 years later, in Maneka Gandhi versus Union of India 1978, it was basically a passport case. Passport case in the sense Maneka Gandhi's passport was confiscated. Her passport was not renewed. She wanted to travel abroad. Although she did not win the case personally, it was said that it's the discretion of the state whether to give you passport or not. Your passport is rightly confiscated and not renewed, so there is nothing wrong there. But the court made other observations which had lasting impact on India's jurisprudence. The court basically said, we don't follow procedure established by law, we follow due process of law. Right to travel abroad is your fundamental right under Article 21 of the Constitution. So we will protect you against the executive, we will protect you against the legislature as well. Because even the law which is passed by the legislature has to have the essence of equality under Article 14. What is that essence of equality? Under Article 14, I told you, you have the right against arbitrariness. The state cannot take an arbitrary decision. State includes legislature. So when the legislature cannot take an arbitrary decision, your law also has to be reasonable. Your procedure has to be right, just, and fair. And the court further said, we also follow principles of natural justice. Sir, what are these principles of natural justice? Not mentioned anywhere, but these are universal principles that we follow. And these principles are part of the Constitution. And what are these principles of natural justice? I think we will take a break. And after the break, we will come back and discuss what are these principles of natural justice, what happened in this Maneka Gandhi case. And then we will discuss if we have right to life, do we have right to die as well? And if we have or have not right to die, later on we will discuss previous year's question papers as well. Pinto, for your question, BHLP. You should extend BHLP, not BTLP. Okay, let's meet at 8:05. See you on the other side of the break. Article procedure established by law. Constitution. Article 21 of the Constitution. No person shall be deprived of his right to life or personal liberty except according to the procedure established by law. The court has said that life is not a physical act of breathing alone, which means you're allowed to breathe and that satisfies Article 21. No, right to life means something else as well. Right to decent environment, right to livelihood, right to shelter, right against solitary confinement, right to fair trial, right to speedy trial, right to privacy as well, right to decent environment as well, right to a meaningful life as well, right to life with dignity as well. But this fundamental right is not absolute because under the procedure established by law, your right to life or personal liberty can be snatched, can be deprived. But what is this procedure established by law which we have borrowed from the Japanese constitution? If someone's right to life is violated, the court will prescribe and perform 3 tests to check whether this right was violated according to the procedure established by law or not. First, there has to be a law. Second, this law has to be valid. Third, the procedures mentioned in the law should be followed or not. Which means using procedure established by law, the court can protect you against the arbitrary actions of the executive. But what if the law is bad? What if the law is horrible? What if the procedures are unfair, unjust, unreasonable? The courts are helpless. But in United States, the courts will protect you against the legislature as well, against the arbitrary actions of the legislature as well, because they follow due process of law, where test number 4 is prescribed, conducted, whether the law is fair, whether the procedures are just, right, and reasonable. And we have evolved from procedure established by law to due process of law, using judicial creativity. Because what is constitution after all? Constitution is what the Supreme Court says it is. Because who is the final interpreter of the Constitution? Supreme Court. Supreme Court said in A.K. Gopalan case, we follow procedure established by law. In ADM Jabalpur's case, which is also known as the habeas corpus case, the Supreme Court said we follow procedure established by law. But 2 years later, in 1978, in Maneka Gandhi case, Supreme Court said we follow due process of law. Which means now the judiciary in India will protect you against the arbitrary actions of the executive as well as the arbitrary actions of the legislature as well. The Supreme Court will go behind the intention of the legislature to decide whether the law is just or not, whether the procedures are reasonable, right, and fair or not. And the court further said we follow the principles of natural justice. And how did the Supreme Court arrive at this conclusion? Because it has to give a reason as well. Why are we saying due process of law and not procedure established by law? Because the court says, look at Article 14 of the Constitution. Article 14 gives us a right against arbitrariness. And whether the arbitrariness is performed by legislature or executive doesn't matter. Every organization, every organ of the state should not be arbitrary, has to be reasonable in its dealings. And the court said principles of natural justice, although not found anywhere in the Constitution, not mentioned explicitly anywhere in the Constitution, but these are the universal principles which we follow. And what are these principles of natural justice? Number 1, nobody shall be sentenced without being heard. If you and me have a dispute, matter goes to the court. The court is only hearing my side of the story, not yours. The court is hearing only the evidence that I have collected, not yours. That is something which is against the principles of natural justice. Nobody shall be sentenced without being heard, which means no ex parte verdicts. Without hearing the other side, you cannot decide whether I'm guilty or not. You have to hear my side of the story as well. You have to hear both parties. You cannot exclude one party and decide your verdict based on the arguments given by one party to this dispute. Nobody shall be sentenced without being heard. No person shall be the judge in his own case. It's not only specific to a judge. It is specific to some other organs as well. Some other organs in the sense, if the job of the executive is to issue passport, it should not be the executive which would get to decide whether this passport is rightly given or wrongly given. That means you can't be the judge in your own case. You will issue the passport as well, and you will also be the deciding authority to decide whether passport should not be given. And even if a judge is accused in a particular case, the judge cannot sit on the chair and say, I have declared, looking at all the evidence, that I am not guilty, I am innocent, I am set free. And the authority shall act bona fide, in good faith. When the legislature is enacting a law, its intention should be good. Intention in the sense, a legislature is passing a law primarily to punish one community or one caste group or one linguistic group. No. You have to act in good faith. You should not be punishing a specific group. The law has to be for everybody. You can't make specific laws for specific communities and target them through your laws. We follow principles of natural justice, said the Supreme Court in 1978. Supreme Court further said in Central Inland Water Transport Authority versus Brojonath Ganguly that principles of natural justice are found in Article 14 itself. It's not something that we have innovated. It is something which is found in Article 14 itself, right to equality, right against arbitrariness, which means you cannot be the judge in your own case. You have to give equal treatment to both the parties. You can't hear one party as against the other. And you have to act in the good faith. You can't take an arbitrary decision, make an arbitrary law, and punish only one community or one specific group. Principles of natural justice. But if in 1978, the Supreme Court said, we follow the principles of natural justice, wherein one principle is no person shall be the judge in his own case. This was when the Supreme Court was at its glory. Glory in the sense giving glorious verdicts, expanding the scope of fundamental rights, challenging the executive if the executive is violating the rights of the people. And then we saw that some people allege that till 2014, the Supreme Court was independent in its approach. But slowly and steadily, it has come under the grip of the executive. Whatever executive wants, judiciary delivers it. That means, allegation is that some chief justices consistently, continuously, since 2014 onwards, they have not been in a position to uphold the rights of the people, barring few exceptions. Some people say the exception is Justice Thakur. Justice Thakur was an exception. And some people say that today Justice D.Y. Chandrachud is trying to redeem the image of the Supreme Court, the image which took a hit during the period of 2014 onwards. And they cite the examples, multiple examples, which we will discuss in judiciary. But one such example is of Justice Ranjan Gogoi. The predecessor of Justice Ranjan Gogoi was Justice Deepak Misra. We will discuss in Supreme Court, in judiciary, that there is something known as collegium, consisting of Chief Justice of India plus 4 senior judges of the Supreme Court. And it is this collegium which recommends names to the president that these judges should be appointed to Supreme Court, these judges should be appointed to the High Court. Clear? When Justice Deepak Misra was the Chief Justice of India, these 4 senior judges of the Supreme Court did a press conference. The year was January 2017. A historic press conference. In a sense, this is something which we never witnessed in independent India. This is something that we never saw happen for the first time in January 2017. Who were these 4 senior judges of the Supreme Court? Justice Chalameshwar, Justice Kurian Joseph, Justice Madan Lokur, and one judge was Justice Ranjan Gogoi. What did these judges say? These judges said, democracy is in danger. Why democracy is in danger? Because these judges allege that there is some sort of bench fixing which is taking place. Just like match fixing in cricket, there is bench fixing happening in Supreme Court. What is this bench fixing? Who is the Chief Justice of India? I told you yesterday, master of the roster, or day before yesterday. That means when the cases come before the judiciary, it is the Chief Justice of India who, on the administrative side, will get to decide who are these judges who will hear these specific cases, allocates responsibilities to various judges. These four judges are saying and alleging that when important cases come before the Supreme Court, involving politicians, for example, involving the government of the day, for example, deliberately what Justice Deepak Misra, as the Chief Justice of India, as the master of the roster, is doing, allocating these cases to junior judges, not to these senior judges, so that these junior judges can give favorable judgments to the executive, can give favorable judgments to the government of the day. Because those junior judges, some of them, they are very close to the ruling party. So bench fixing is taking place. Because if there is a case which comes before the Supreme Court, I can today know what is the outcome of this case, what is going to be the verdict of this case, by looking at who is the judge who is hearing this case. If this case is against the government, the judge allocated to this case to hear this case is somebody who is close to the government. This judge will give a favorable verdict in favor of the government. That is why these four members of the collegium, these four senior judges of the Supreme Court, they said democracy is in danger. Everybody praised these four senior judges of the Supreme Court at that time, but particular praise was given for Justice Ranjan Gogoi. Shekhar Gupta, for example, who was then the editor of Indian Express, right now runs a news portal called theprint.in, runs a popular YouTube channel as well. You should watch some of his videos, thoroughly researched. But the point is, just Shekhar Gupta says a word of thought for Justice Ranjan Gogoi. Because Justice Ranjan Gogoi is in line to become the Chief Justice of India. And in India, outgoing Chief Justice nominates his successor. So outgoing Chief Justice, Justice Deepak Misra, has to nominate his successor, who should be the senior judge of the Supreme Court. So if the senior most judge of the Supreme Court after the retirement of Justice Deepak Misra is Justice Ranjan Gogoi, and Justice Ranjan Gogoi has to become the Chief Justice of India, he should be nominated by the outgoing Chief Justice, by Justice Deepak Misra. But by leveling allegations against Justice Deepak Misra, maybe Justice Deepak Misra would not recommend his name, would not nominate Ranjan Gogoi as the Chief Justice. So people praise Justice Ranjan Gogoi, saying he staked his office of the Chief Justice of India for the sake of democracy. Wow, what a man. Why was Justice Deepak Misra, why was it alleged that he was giving favorable verdict in favor of the government of the day? It was alleged that there is some corruption vis-a-vis a medical college. There was a private medical college in UP. It was barred by the Medical Council of India from taking more admissions, fresh admissions, because it had violated the Medical Council rules. The owner of that private medical college, later on it was alleged that he was in touch with few people to get a favorable verdict from the Supreme Court, because that owner of the private medical college would challenge this decision of the Bar Council in the Supreme Court. And there were some judges, Justice Kudusi from Odisha, for example, who was alleged to have taken bribe to get a favorable verdict from the Supreme Court for this private medical college. And he got the favorable verdict. And that favorable verdict was delivered by Justice Deepak Misra. So it was alleged that Justice Deepak Misra would have also received some money from Justice Kudusi to give a favorable verdict to this private medical college. Everything is known to the government. Everything is known to the government because government has a lot of tools, lots of agencies to keep a track of people. They can conduct surveillance on the people as well. They have a lot of resources at their disposal. So if the government knows that Justice Deepak Misra, these are all allegations. These are not my personal statements. These are all allegations. If the government of the day knows that Justice Deepak Misra has committed some wrongs, maybe has indulged in corruption, They will use this to blackmail Justice Deepak Misra. Give favorable verdict for us, otherwise we will remove you or we will send you to jail. You will become the first Chief Justice of India to see the light of the jail. But then when Justice Ranjan Gogoi became the Chief Justice of India, there was another allegation against him. What was the allegation? Sexual misconduct. One lady who was working in the office of Justice Ranjan Gogoi. At that time, Justice Ranjan Gogoi was not a Chief Justice. But when she was working in the office of the judge, sometimes she would work from the home of Justice Ranjan Gogoi as well, because the judges' homes, these are also meant to be offices where they do their official work. This lady alleged that she was sexually harassed by Ranjan Gogoi. Nobody listened to her. Her husband was in the police. He was dismissed from the police. Her brother-in-law was in the court, was a clerk in the court. He was also removed from the service. And this lady, she was also removed from the service. And later on, it came to be known that there was a software, Pegasus, from an Israeli firm, which was used to conduct a surveillance on important personalities in India. For example, it is alleged that the government bought this software from Israeli firm known as Pegasus. This software was used to conduct surveillance on important political leaders, important figures. For example, Rahul Gandhi. For example, one minister, Mr. Ashwani, who is the railway minister, other opposition leaders as well, journalists as well. One such individual where it is alleged that this Pegasus software was used to keep a track of was the lady victim who accused the judge, Justice Ranjan Gogoi, of sexual misconduct. And nobody is listening to her side of the story. Ultimately, she approaches two online portals, the Caravan and the Wire.in, to publish her story. And when the story was published in the Wire and the Caravan, the very next day, Chief Justice of India is setting up a bench. Important matter. Dealing with the independence of judiciary. The very next day, after these allegations were published in the news portals, Chief Justice of India, Justice Ranjan Gogoi, set up a bench of two other judges. So total, there are three members of this bench. And what are they hearing? They are hearing an important matter concerning the independence of judiciary. And while hearing this matter, Justice Ranjan Gogoi is leveling allegations against that lady, casting aspersions on her character. Basically, he's saying that this is a conspiracy to deactivate the office of the Chief Justice of India, to prevent Ranjan Gogoi from carrying on with his office. But then he said, I will not further hear this case. Let these two judges decide what should be done in this particular case. I will step aside. And these two judges said Justice Ranjan Gogoi is innocent. But Prashant Bhushan and other lawyers, they approached the Supreme Court, these two judges, and said, you should not hear this case. Someone else should hear this case. Why? Because it violates principles of natural justice. You should not be the judge in your own case. These two judges said, but how are we the judges in our own case? Allegation is not against us. The lawyers are saying, but the allegation is against somebody who set up this bench. Allegation is against the master of the roster who gave you this responsibility, so you will be biased in favor of that individual. This case should not be decided by the Chief Justice of India, by someone else, because you are violating principles of natural justice. Supreme Court was taken by surprise. And Supreme Court said this principle, that no person shall be the judge in his own case, applies to everybody except Chief Justice of India. So look at the fall. From 1978, when Supreme Court said, although principles of natural justice are not mentioned anywhere in the Constitution, but these are universal principles. These universal principles are present in Article 14 as well. And apart from due process of law, we follow principles of natural justice. The rise of the Supreme Court, then to the fall, where the Supreme Court says this principle applies to everybody except the Chief Justice of India. But be that as it may, we will discuss this in great detail in judiciary when we will discuss the topic, the crisis in judiciary, or how can we reform and redeem judiciary. This is Article 21, right to life and personal liberty, which can be violated, but only according to the procedure established by law. And procedure established by law in India today means due process of law. And it also includes the principles of natural justice. Then came the question, if we have a right to life, does that mean that the immediate corollary, the immediate inference should be that people should have a right to die as well? Supreme Court has expanded the scope of Article 21 to say right to live with dignity. If there is no dignity in your life, you should be allowed to snatch your own life. Right to die should also be a fundamental right under Article 21, which basically means that Section 309 of Indian Penal Code, which talks about criminalization of attempt to suicide, should also be unconstitutional. Section 309, if I am an individual, I want to commit suicide. If the suicide is successful, that means I'm dead. Nothing will happen to me. No case can be filed against a dead person. I'm dead. I'm too dead to be in jail or to be hanged. But if this suicide fails, that means my attempt to suicide fails, then according to Section 309, I am a criminal. Because I tried to snatch my own life, I am a criminal, I will be sent to jail. The question before the court was, if we have right to life, should it not mean that we should have a right to die as well? Which basically means Section 309 of Indian Penal Code is unconstitutional. Matter went to the court. The judgment was Ratinam. 1992 or 1994, this is when the judgment was given. The year is not important, the case is important. Ratinam. Supreme Court said, yes, we have right to die. Because the corollary is, the immediate inference is, when you have right to life, you have right to die, which means right to die is also a fundamental right, which means Section 309 is unconstitutional. 2 years later, in Gyan Court versus State of Punjab, Supreme Court said no. There is no such thing as a right to die. Section 309 is constitutional. You can't take your own life. Right to life is limited to it. Right to die is not a fundamental right. But something else had happened in 1973. Aruna Shanbag. She was a nurse at the King Edward Memorial Hospital in Mumbai. Fell in love with a fellow doctor. They were happy together. They were all set to marry. Then one fateful night enters a man who tries to sexually assault Aruna Shanbag. He was also working in this hospital. Some people allege that he was not given leave. That is why he was dissatisfied. Some people said a complaint was filed against him by Aruna Shanbag. That is why he was very irate. But whatever may be the reason, this man tried to sexually assault Aruna Shanbag and later on hit her head with an iron rod. When she was hit by the iron rod, ultimately Aruna Shanbag, she entered into a permanent vegetative state. What is this permanent vegetative state? For example, if an individual meets with an accident and then enters into coma, there is a possibility that you will come out of it, you will wake up again. Clear? But if you are declared permanent vegetative state, you are in a permanent vegetative state, which means you are brain dead. Which means there is no scope of survival. You will never come out of this state. Whether today, tomorrow, 10 years, 20 years later, you will have to die, you will never survive. You will not come out of the state, permanent vegetative state. But she was taken care of by the nurses. In fact, a separate room, a separate bed was allocated to Aruna Shanbag, where the nurses were taking care of her, where the nurses were changing her clothes, they were feeding her. And some say that she was also exposed to music. Whenever a particular music was played, she would respond. Somehow she would respond. Maybe she would blink an eye, but somehow she would respond. So she would enjoy a particular set of music as well. Then, over a period of time, her friend Pinky, she approaches Supreme Court. Pinky Virami approaches Supreme Court, asks the Supreme Court a question. Sir, do we have right to life? The court says, yes, we have right to life. Sir, does that mean right to life means physical act of breathing? Or does it mean right to life with dignity? The Supreme Court said, yes, it can't be normal life. It can't be just physical act of breathing. It has the right to live with dignity. Aruna Shanbag is not living the life of dignity. She can't change her own clothes. She can't feed herself. She can't answer the nature's call. She is not living the life of dignity. She is brain dead. Please let her die. And what Pinky is basically asking for, she's asking for euthanasia. And what is euthanasia? Mercy killing. There is somebody who is under a lot of pain because suffering from a terminal disease from which there is no hope of survival. But the only thing which will happen is that you will have to spend thousands and lakhs and crores of rupees just to keep you alive. But even then, it won't be a meaningful life. It will be the life of torture. Why can't we have mercy on that individual? Let that individual die. So the question before the court was, if we have right to life, which means right to live with dignity, that right to life with dignity should include euthanasia, mercy killing. And let Aruna Shanbag die. Supreme Court said we will divide euthanasia into two. into two broad groups because it is divided into two broad groups. This is not something that we innovate, but euthanasia is of two types: active euthanasia and passive euthanasia. We will not allow active euthanasia, but we will allow passive euthanasia till the Parliament legislates on this matter. And what is active euthanasia? An active outside support is used to kill. And what is passive euthanasia? An outside support is used to keep an individual alive. How? There is an individual suffering from a disease, a terminal disease, from which there is no hope of recovery. Active euthanasia would be, because we want to have mercy on this individual, active euthanasia would be the doctor will come up with an injection, will inject this medicine into the veins, into the blood of this patient, and ultimately the patient dies. That means we are killing this individual, but with mercy. We're having mercy on this individual because this individual is suffering a lot. But by using an external device to kill an individual, external medicine, external device, external injection to kill an individual, this Supreme Court says we cannot allow, because this is active euthanasia. We will not allow active euthanasia. We will allow passive euthanasia. And what is this passive euthanasia? An individual is in a permanent vegetative state, brain dead. Then how is this individual surviving? Because of an external support. What is that external support? For example, a ventilator. This person is on the ventilator support. If we switch off the ventilator, the person will die. That means what is keeping this person alive? An external support. If we stop that external support, if we cut the oxygen supply, for example, the artificial oxygen, the person will die. This is something that we will allow till the Parliament decides to make a law on this matter, because right to life with dignity is a fundamental right, which means passive euthanasia is allowed, but subject to conditions. What are the conditions? Family members should be in agreement. If the family says, no, we want to take care of this person, who are you to decide that? We will spend whatever money we have to keep this person alive. We love him. We love her. We don't want this person to die. We will take care of her. We will leave the matter to God. Maybe the God will have some miracle and will save this individual. We are not in agreement. But if the family is in agreement, okay. Second, panel of doctors should also be in agreement. The doctors panel should be set up, maybe 2 doctors, 3 doctors, they should be set up. Why? Because these doctors should say and confirm that this particular patient is in a permanent vegetative state. That means there is no chance of survival. There is no hope of survival. You're only prolonging the number of days this individual is alive. There is absolutely no hope for recovery. And then High Court. Then this matter should be given to the High Court concerned. 2 judges of the High Court should decide whether this person should be killed or not, whether we should have mercy on this person, whether passive euthanasia should be allowed or not, whether you can now cut the ventilator support, cut the oxygen supply. Pinky Virami, on Aruna Shanbag case, right to life with dignity is a fundamental right. Since 1973 till 2011, because this judgment was given in 2011. Aruna Shanbag is suffering. Right to life with dignity is a fundamental right. Passive euthanasia is allowed. But Aruna Shanbag was not allowed to kill herself. Despite this judgment, Aruna Shanbag lived. And for 42 years, she was in a permanent vegetative state. Ultimately, she passed away. The reason for her death was pneumonia. Despite right to life with dignity, a fundamental right, passive euthanasia could not be implemented for Aruna Shanbag. Why? Because there was no family. So now there is no such thing as family should be in agreement. The court was asked, what if there is no family? Who will take this decision? Who should be in agreement? Court said, in absence of family, the next friend should give the consent, should give the permission. Now the challenge before the court was to decide who is the next best friend of Aruna Shanbag. Is the next best friend Miss Pinky? Or is it the nurses who are taking care of her at the King Edward Memorial Hospital in Mumbai for many decades? And ultimately, the court said it is these nurses who can be treated as the best friend of Aruna Shanbag. And nurses were not in agreement with passive euthanasia. They wanted to take care of Aruna Shanbag. And that is how, despite this judgment, although passive euthanasia was allowed in India, but Aruna Shanbag could not get the benefit of this because the next friend were treated as the nurses were treated as the next friend of Aruna Shanbag. But be that as it may, few years later, the court further expanded the scope of Article 21. And the court said, right to make a living will is also a fundamental right under Article 21 of the Constitution. What is this right of a living will? It was argued that today we get to decide on the basis of the family members, whether family wants euthanasia or not, whether the next friend wants euthanasia or not. Why should we leave it to the family? Why can't an individual himself or herself get to decide? For example, if I have the property, after my death, who gets to own this property? I decide it while I'm alive. This part of my property should be given to charity. This part of my property should be given to my spouse. This part of property should be given to my kids. This part of property should be given to my brother or sister. I get to decide while I'm alive. Similarly, while I am alive, can I not make a living will? What is this living will? If something happens to me tomorrow, where I am unable to take any decision as to what should be the medical options available in my case, I will already have mentioned it in my living will. Let's say, for example, if tomorrow something happens to me, I am put on a ventilator, I'm about to be put on the ventilator support. This living will would mention no ventilator at any cost. While I'm healthy right now, I will make a living will that tomorrow when I'm unable to take any decision, if I'm in a permanent vegetative state, I will mention that this is the form of treatment that should be given to me. I should not be put on the ventilator support. My limbs should not be chopped off. If tomorrow I meet with an accident and then I'm in my subconscious state, I'm unable to decide, the doctors will have to tell my family members, if we want this person to survive, we have to chop off both of his limbs because we can't save both the limbs. I should be able to decide because after that, I cannot live the life of dignity. Don't save me. Don't chop off my limbs. Don't do that. I will make this living will. I will upload the digital copy of this living will. This will be attested by the gazetted officer. The gazetted officer will attest this, saying, yes, this will was presented by this individual when he was healthy, in presence of a witness. So tomorrow, whenever this situation arises, this living will be presented before the doctors, and the doctors will look at this living will and accordingly take a decision. This right to make a living will is also a fundamental right under Article 21 of the Constitution. And today, Section 309 of Indian Penal Code is superseded by the Mental Health Care Act of 2017. And what is this Mental Health Care Act? Is if somebody attempts suicide. If the suicide is successful, you are too dead to be redeemed. But if the suicide fails, then you won't be treated as a criminal. You will be treated as someone who needs care, as someone who is not mentally fit. That means now it is the Mental Health Care Act of 2017 which comes into prominence. According to this law, if somebody is attempting suicide and if it fails, don't treat this individual as a criminal. Treat him as somebody who requires medical attention, mental attention. Why? Because this person requires care, he's not mentally fit. That is Mental Health Care Act of 2017. And that completes our Article 21 of the Constitution. Any questions, please let me know. Somehow some slides are missing. I will check it why it happened. But Article 21 capital A is missing, Article 22 is missing, but you don't have to worry, we will discuss. Not part of the slides, but I will write everything that you need to know. But first up, any questions on right to life, please let me know. Now we follow due process of law. Can no post-mortem be also written in the living will? No, that is a procedural thing that should happen. She married, so her husband is a family. She was about to get married. She was not yet married. Is Parliament competent to decide on active euthanasia? Yes, if they want to give active euthanasia as well, they are free to do that. Sir, if due process of law is followed, then why did Supreme Court upheld Prevention of Money Laundering Act? It may be a tough law, but it is not an unfair law. Yes, we need a law which can prevent money laundering because that has an impact on our economy. So it's a tough law, but that doesn't mean it is unfair law. A tough law is not an unfair law. Similarly, we need a tougher law against terrorism. Just because a law is tough, that doesn't mean that it is unjust. Sir, if right to shelter is a fundamental right, then the people who don't have the house can go to the Supreme Court, right? If they go to the court, then will the court provide houses to all those people who don't have houses? Example like beggars. Even this right is not absolute. That's one thing. Two, something happened in Uttarakhand, in the Haldwani district of Uttarakhand. There were people who, according to the government, had encroached upon the railway land. For decades and decades, they were residing on that railway land, which the government says is the railway land. But now the railways wanted to take that land back. So, what they wanted to do, they wanted to evict all those who had made houses on this land. They approached the Supreme Court. Supreme Court said, yes, there can be, you can evict these people if they have encroached upon the state land. But there can be no eviction without rehabilitation. So all these people who will lose their land, who will lose their houses, you will have to rehabilitate them somewhere. After that, you can evict them. That is what we mean by right to shelter being a fundamental right. Sir, cases discussed in this is important for exam. My dear, if these cases were not important, we would not be discussing. These cases are important. Please remember these cases. Okay. Can habeas corpus be applied in case of preventive detention? If you need an answer now, I would say the answer is yes. But we will discuss this in Article 22. Will use to kill that person who needs euthanasia. I don't get your questions clearly, but doctors will pull out the ventilator support. So you don't need an external device to kill an individual. You don't need a gun to shoot that individual, because that would be active euthanasia, which is not allowed. But if that person is on the ventilator support, and if I'm in agreement, then what will happen? This person's ventilator support will be cut and that person will die. Yes, it is. But who can judge the judge? Because we say today there are no checks and balances on the judiciary. Judiciary can do anything in India. In 2017, 9-judge bench of the Supreme Court, by the majority of 9:0, that means all the 9 judges agreed that right to privacy is a fundamental right under Article 21 of the Constitution. The question can be on your mind, sir, why some cases are heard by 5 judges, some cases are heard by 9 judges, some cases are heard by 13 judges, some cases are heard by 2 judges. How do we decide this? There is something known as a constitution bench. Constitution says any judge, any bench, when the Supreme Court has to hear a constitutional matter, let's say a matter involving interpretation of the Constitution, let's say fundamental rights for that matter, such a case should be heard by not less than 5 judges. Normally, Supreme Court sits in a bench strength of 2. For example, 2 days ago, when there was a judgment to be given where a lady wanted to terminate her pregnancy because she was feeling some disorders, the Supreme Court allowed it. But then All India Institute of Medical Sciences, they sent a mail to these judges and said, how do we perform abortion? How do we terminate this pregnancy? Because the fetus is alive, fetus is breathing. So should we kill the active fetus? Justice Nagaratna, she was one of the judges on this bench. She said it is ultimately the right of the woman. If she does not want pregnancy, if she does not want the child, you have to abort the child. The other judge, Justice Kohli, said, my judicial conscience will not allow me to allow killing of an active breathing fetus. So normally they hear a matter in two judges. That means two judges hear a particular matter. But when there is a disagreement, one judge says allows, one judge says don't allow, then they refer this matter to Chief Justice. Now, Chief Justice will have to set up a three-judge bench. Why? Because if two judges do not agree, we need a higher judge strength, a three-judge strength to decide on this matter. But if it's a constitutional question, if a matter involves interpretation of the Constitution, let's say, for example, Article 370 petitions, whether it was rightly done or not, whether Constitution was violated or not, that judgment was heard by 5 judges. But why right to privacy was heard by 9 judges? It is a constitutional matter because we have to decide whether right to privacy is a fundamental right or not. But the Constitution does not explicitly mention that right to privacy is a fundamental right. But previously in the 1950s and 60s, 8-judge bench had said right to privacy is not a fundamental right. In the 1950s, 1960s, initially 5-judge bench, 6-judge bench, later on 8-judge bench, they said right to privacy is not a fundamental right. Then came Aadhaar. And I told you in the first class or second class how Aadhaar was viewed as something which violates privacy. Because through Aadhaar, your life is as transparent as a contact lens. Now the question before the court was, is Aadhaar constitutional? Because it violates privacy. Mr. Arun Jaitley, who was the finance minister, he said, right to privacy is not a fundamental right because it's not mentioned in the Constitution. And in fact, 8 judges previously have said right to privacy is not a fundamental right. Mr. Puttaswamy, who was the retired judge of the Karnataka High Court, he filed a petition before the Supreme Court saying Aadhaar violates right to privacy. And since right to privacy is a fundamental right, Aadhaar is unconstitutional. But the government says, where is it mentioned that right to privacy is a fundamental right? Because 8 judges previously have said right to privacy is not a fundamental right. So to examine, to review a judgment given by 8 judges, you need a higher judge strength. That is how 9 judges were set up by the Supreme Court. And all these 9 judges said right to privacy indeed is a fundamental right. Because look at the preamble. Preamble talks about one objective of the Constitution is dignity. And you cannot assure dignity without providing right to privacy. Right to privacy is a fundamental right. But then right to privacy, even if it's a fundamental right, is not an absolute fundamental right. This right to privacy can be violated for legitimate state interests. What is a legitimate state interest? There is terrorism in India, cross-border infiltration in India. Should we not survey on some people if they are under suspicion that they might commit a crime? That means we have to intrude into their privacy. Maybe we have to tap their phones. Tapping phone violates privacy. But is phone tapping allowed? It is. If it is in the legitimate state interest. So right to privacy can be violated because it's not an absolute fundamental right, but only when legitimate state interest is involved. Because right to life under Article 21 is not an absolute fundamental right. But for that you need a law. This law would lay down procedures. How can you tap the phone? Who gives you the permission to tap the phone? It cannot be a random constable is tapping your phones. You need the permission of the Home Secretary. You need the permission of the DGP. It has to be done at the higher level. And then this phone tapping, what you are tapping, the details that you are tapping, you have to safeguard them as well. And after 90 days are over, you have to discard all this information. All these procedures are to be followed, otherwise you would be violating Article 21. This is Article 21 of the Constitution. Then something else happened. Unikrishnan case, Unikrishnan versus State of Andhra. In this case, the Supreme Court had said right to education is also a fundamental right under Article 21 of the Constitution. Because right to life means a right to live with dignity as well. This dignity is possible with education, because life is not just a physical act of breathing. Life should also include life to a decent living, which can happen through education. Right to education is a fundamental right. But the court did not elaborate what sort of right to education is a fundamental right. Is it right to primary education? Is it right to early childhood care? Is it right to secondary education? Is it right to professional education? Is it right to technical education? What sort of right to education is a fundamental right? Then in 2001, 86th Constitutional Amendment Act was passed. Article 21 capital A was added to the Constitution. And it is this Article 21 which talks about right to compulsory primary education for all the children in the age group of 6 to 14. So 6 to 14 years, right to primary education till the 8th standard becomes a fundamental right for all the people in India, for all the children in India. And to implement this act, Right to Education Act was passed by the Parliament in 2009, which came into force with effect from 1st April 2010. And according to this right to education, eight years of continuous schooling is a fundamental right, that too in neighborhood. No child shall be denied admission for want of documents. The state has the responsibility to ensure attendance as well as retention, and no child shall be detained. This is what we know as no detention policy. 1986, Unikrishnan versus State of Andhra. Supreme Court held right to education is also a fundamental right. But what sort of education? That clarity we got when the Constitution was amended for the 86th time in 2001, when the right to compulsory primary education was made a fundamental right for all children in the age group of 6 to 14. 6 to 14. That means 8 years of continuous schooling is a fundamental right. And to implement this fundamental right, RTE, Right to Education Act, was passed in the year 2009, according to which in your neighborhood you should be given educational opportunity. That means the state has the responsibility to set up schools at such locations in such a manner that a student need not travel far distances to get access to education. Because if I have to travel to far distances to get education, I will drop off. The drop off rate would increase. So ensure that 8 years of continuous schooling, that too in the neighborhood. No child shall be denied admission for want of documents. The child approaches the school for admission along with the parent, and then questions are asked: where is your birth certificate? Where is the municipal certificate? Where is the income certificate? Where is the eligibility certificate? Right now, where is the Aadhaar? So many documents, and ultimately when these poor people don't have these documents, they run away, they drop off, they don't enroll their kids into schools. The law says no child shall be denied admission for want of documents. You don't have to care where this child is coming from. The child is there, admit. And then the states have the responsibility. You have to ensure that these children, they come to the school, ensure their attendance, ensure they are retained as well. That is how midday meals are provided to these kids. Nutritious food is provided to these kids to lure them so that at least for this food, they can come to the school and we will teach them. Because we have a massive population of young people. If we don't give them educational opportunities, we can't reap the benefits of this demographic dividend. And no child should be detained. Detained in the sense, I am in the 5th standard along with my friends. All of them passed the examination. I failed. They will be promoted to 6th standard. I will remain in the 5th standard. What will happen to me? In my class, then I have to make new friends. And my old friends will tease me, hey, you got failed. We told you you should study. Ultimately, what will happen? It will be like a psychological pressure to me. I will drop off. I will not go to the school. The intention of the RTE Act was to ensure that the children do not drop off from the school. You fail in the 5th standard, don't worry, you will be still promoted to the 6th standard. You fail there as well, don't worry, you will be still promoted to the 7th standard. You fail there, don't worry, you will still be promoted to the 8th standard. Because the intention is that we should not let you drop off. But then the state said, it is this no detention policy. It is this no detention policy which is leading to declining quality of education. Declining quality of education, because when you are not detained, when you are not failed in your exams, it basically means you will not study, because then you know you will be promoted to a higher grade. And that is how, when new national education policy is passed, this new national education policy gives the discretion to the states. If you want, you can do away with this no detention policy. You can even fail the students if they fail to qualify the exams. And Tamil Nadu became the first state to formally do away with this no detention policy, saying it is leading to declining quality of education, declining quality of learning outcomes. But perhaps this is wrong. Perhaps no detention policy should have continued. Why? Because no detention policy was not meant to be a standalone policy. It was not meant to be a standalone policy saying we will not detain kids if they fail the exam, that's all. And our intention is to not lead to a drop off percentages, increase in the drop off percentages. No, there was meant to be CCE, continuous curriculum evaluation. Teachers should have been trained to evaluate these students continuously. Why are they failing? Maybe they need an extra class. Maybe they need an extra attention. Maybe some of the curriculum should be revised because they find it tough to understand some topics. That assessment should have been done. So, no detention policy was not meant to be a standalone policy that we will not detain and that's all. It was meant to be supplemented with CCE, continuous curriculum evaluation. Maybe extra help, maybe extra support, maybe extra classes, maybe a different way of teaching these kids. So the failure of no detention policy is not the failure of the students, it's the failure of the teachers. It's the failure of our system, which has failed to devise these policies better. And RTE Act also talked about 25% seats in private schools should be reserved for weaker sections of the society. And on this, there was one movie which was loosely based on this particular clause in RTE Act, and that movie was Hindi Medium. Some of you may have watched that movie. It was a good movie starring Irfan Khan. Private schools, if they have 100 seats, they have to reserve 25 seats for the economically weaker sections of the society. That means there is an international school here. In the vicinity, there are slums. 25% of the seats should be reserved for these weaker sections of the society. They don't have to pay the fee, but they will get good quality education. That is mentioned in the RTE. Some people praise this provision, saying now finally, even the poor, even the students belonging to the marginalized communities, they will have access to quality education. But there are psychologists, child psychologists, who question this provision. They say, imagine the burden on this child who is coming from an economically weaker section of the society. Now, there are 25 kids who are poor, from poor marginalized communities. 75 people are from rich families. They're part of the international school. They pay the fee, not these 25 students. Will the teacher cater to them or cater to them? They will be discriminated inside the class. And look at the psychological baggage. They don't have tiffin, but these people come with fancy tiffins, fancy geometry boxes, fancy pencils and sharpeners and erasers. And then these 25 kids, they will curse themselves. And then some of them will be psychologically disturbed as well, mentally disturbed as well. What wrong have we committed that we were born in the families of poor people? They have iPhone as well. They don't have even a random normal phone. And that is how there have been some research studies conducted wherein some of these students, unfortunately, later on, they steal valuables from other houses, from their own houses, so that they can match the dignity which is provided by the members of the rich, by the children of the rich people. They say this 25% reservation should not continue. Instead, the state, instead the government funded schools, their infrastructure should be enhanced. Their infrastructure should be enhanced so that the poor should also get quality education, not in private school, in the government schools itself. And one more important point, continuous curriculum evaluation. The teacher should be able to understand the students. And if a student is good in maths, he should be encouraged to opt for non-medical. If a student is good in biology, life sciences, should be encouraged to opt for medicine, because only a teacher would know what is your capability, how are you doing, how are you performing, how are you reciprocating. But there may be some students who will not be good in studies. Should that be the end of the world? No. Why don't we follow a German model? What is the German model? Skills are imparted. Painting, plumbing, electrician's work, maybe paper mache, wood carving, some other skills should be imparted to these children. So that if they're not good in educational opportunities, if they're not good in studies, we should not force them. Give them basic education, but enhance them with skills so that they can become good plumbers, they can become good electricians, they can become good carpenters and masons. These are also individuals we require in the society. That's something that is happening in Germany, and that is something that we should incorporate in India. That is Article 21, capital A of the Constitution, right to free, compulsory primary education to all children in the age group of 6 to 14. Okay, so we will now take a look at previous year's question papers. We will start poll as well. Question number 1, this was asked in Prelims 2020. A constitutional government by definition is, what is the answer? Weber is asking, if you have to give reservation, then the autonomy of the state should be minimized. Which autonomy and which state? This is the leaderboard. These are the students who have given correct answer. A constitutional government by definition is a limited government. Because what is the purpose of the constitution? To ensure that the powers of the state are not unlimited. We call a government a legitimate government if it is observing the limitations that are imposed by the constitution. Doctrine of limited government. The powers available with the state are not unlimited. There's a limitation on their power. And the limitations are imposed by the constitution. So constitutional government is basically a government, a limited government, a government which is limited in its powers. It's not a government by legislature. It's not a popular government. It's not a multi-party government. Multi-party government means when there are various political parties which come together to form the government. That doesn't mean that's the definition of a constitutional government. Constitutional government means a government which is limited in its powers. This question was asked in prelims. Effective restrictions on the authority of the state in the interest of individual liberty. Which of the statements are correct? Choose those students who gave the quick answer. Maybe this time, if you have given a quick correct answer, your name will be there in the. A constitutional government is one in which places effective restrictions on individual liberty in the interest of the state authority. What is a fundamental right? Negative obligations on the state. The state is asked, don't interfere with the liberty of an individual. So restrictions are imposed on the state in the interest of individual's liberty. So statement 1 is incorrect. Places effective restrictions on the authority of the state in the interest of individual liberty. This is correct. So only 2, B is the right answer. Another question are that they are deactivated by the authority, Unique Identification Authority of India. You cannot come out of Aadhaar. That means once you have enrolled for Aadhaar, you cannot come out of this Aadhaar regime. But this authority, Unique Identification Authority of India, the allegation is that it has been deactivating Aadhaar of people. Wherever there is duplication, wherever there is some concern, this UIDIA is also, the allegation is also deactivating Aadhaar of genuine citizens. So once issued, Aadhaar number cannot be deactivated or omitted by the issuing authority. It can be. But you cannot come out of Aadhaar. On your own, you cannot come out of Aadhaar. This authority, Unique Identification Authority of India, can omit you from this Aadhaar, but you cannot voluntarily come out of it. So neither 1 nor 2 is the right answer. If it's right, the answer is it is a constitutional right under Article 326. Others are not simply attempting these questions. They just want to read these questions and be done with this. Okay. Students are right. These are the students who are both right as well as quick. Which of the following are regarded as the main feature? Equality before law, right? Article 14 is a fundamental right. Fundamental right is basically limitations on the powers of the state, because the powers of the state are not unlimited. There is a limitation. One such limitation is fundamental rights. The state shall not do this, the state shall not do that. Now let's look at the question. Which of the following are regarded as the main features of rule of law? Is it a limit? That's not, we have discussed anywhere in Article 14. In rule of law, we never discuss people's responsibility to the government. It is government's obligation on the people, but not people's responsibility to the government. That may be under fundamental duty, but not fundamental rights. Incorrect. Liberty and civil rights. All the fundamental rights. The chapter fundamental rights is basically to provide liberty and civil rights to the people. This is correct. So 1, 2, 4, C is the right answer. Done? Another question. Take. Which of the following categories of fundamental rights incorporates protection against untouchability as a form of discrimination? Untouchability. It comes under Article 17. Right against exploitation comes under Article 23 to 24. Right to freedom comes under Article 19 to 22. Right to constitutional remedy is Article 32. Right to equality is Article 14 to Article 18, which includes Article 17, which means D is the right answer. Sir, fundamental rights are legal rights as provided by the Constitution, but right to vote is provided by the Constitution. So can we say right to vote is a constitutional right? That is why, my dear, we said right to vote is a constitutional right. It is also a legal right, but sometimes 2 options may be correct. You have to pick the most appropriate answer. Are constitutional rights legal rights? Yes, because they are provided by the law. Clear? But if legal right also, constitutional right also, both are correct, you have to pick the most appropriate answer. Legal right can also be the right provided by the law passed by the parliament, ordinary law. Or legal right can be the right provided by the supreme law of land, which is the Constitution. In case of right to vote, it is the law, it is the right provided by the supreme law of land, which is the Constitution. That is why C is the right answer. Question number: India correctly and appropriately implies the above statement. Article under Article 21 and freedoms which are guaranteed under Part 3 of the Constitution. Which of the following are envisaged? Okay, right against exploitation. We will not touch this part. In essence, due process of law, Article 21. Does that mean equality before law? No. Clearly no, right? Because that's under Article 40. Does that mean procedure established by law? No, because in due process of law, we perform 4 tests. In procedure established by law, we perform 3 tests. Now the doubt is between A and C. Is it principle of natural justice or is it the fair application of law? Even if we were following procedure established by law, even if. What are the 3 tests? There has to be a law. Second, the law has to be legal, valid. Third, procedures mentioned in this law should be strictly followed, which means procedure mentioned in the law should be fairly applied. That means even in procedure established by law, we apply the law fairly because there is a law. In due process of law, we think, is this law fair, reasonable, unjust? Which basically means principles of natural justice. The authority shall act bona fide in good faith. That means if the legislature is making a law, this law has to be fair, which means it is principles of natural justice. Done? In from Article 14, arbitrary action. Very good. But Article 14 does not only talk about equality before law, it talks about equal protection of the laws. So you can say due process of law is basically equal protection of the laws, but not equality before law, because equality before law is negative. Clear? Which of the following, but not the government which is limited in its powers by the Constitution. And the legitimacy of the government will be dependent upon whether this government is observing those limitations or not. So C is the right answer. We'll discuss another question on the chairmanship of Dr. Ambedkar to that is SC, ST, OBC candidates will not be Dipesh, Ram, Piyush, Isha, Dipesh, 1950. On 26 November, drafting committee was set up under Dr. Ambedkar to prepare the draft constitution of India. On 26 November 1949, the constitution was adopted. The full constitution was done, ready. So the drafting committee was set up in the 1946, right? So the statement is incorrect. So statement 1 is correct, but statement 2 is incorrect. Constituent assembly was set up in 1946. Then the drafting committee was set up in 47. Various committees were set up. For example, Union Powers Committee, States Committee, Committee on Fundamental Rights. So many committees were set up, which was not in 1949. Okay, that is it for today. Next week on Friday, we will discuss remaining prelims based questions and we'll discuss all the mains based questions as well. Because in mains you will have to interlink various topics, citizenship with fundamental rights with DPSPs. So unless and DPSPs with Keshavananda Bharati judgment. So next week when we will discuss the DPSPs, all the fundamental rights, Keshavananda Bharati judgment as well, then we will look at all those mains questions which were asked till Keshavananda Bharati judgment. Clear? And we will discuss previous year's MCQs as well. So on Monday, we will discuss first Article 22. Then we will discuss right to religious freedom. We will finish fundamental rights in about 2.5 hours. Then we will jump to directive principles of state policy. Tuesday, we will complete DPSPs and fundamental duties. Then Wednesday, we will discuss the doctrine of the basic structure and how the constitution is amended. Then Thursday, we will discuss president. Then Friday, we will discuss vice president, prime minister, and council of ministers. So union executive, till union executive, we will cover in next week.